Welcome everybody to our second panel of the day on judicial power and checks on the executive branch. My name is Mila Sahoni. I'm a professor here. I teach civil procedure and federal courts. And I'm overjoyed to have the honor of moderating this panel. We have four distinguished panelists today. Samuel Bray, the John N. Matthews Professor of Law at Notre Dame. His primary areas of research are the law of remedies and the law of equity. He's a graduate of the University of Chicago Law School, where he will soon be going to teach. He clerked for our own judge, Michael McConnell, on the U.S. Court of Appeals for the 10th Circuit. Next, we have Melissa Hooper, who is a senior fellow at the German Marshall Fund, focused on rule of law and democracy. Her work includes analysis of the legal impacts of the Trump administration's destruction of government agencies, and she has been affiliated with USAID. Her expertise spans congressional policymaking, teaching, amicus litigation, and public advocacy. Marty Lederman has taught at the Georgetown University Law Center since 2005, with an emphasis on constitutional law, separation of powers, the law of religion, national security, and executive branch lawyering. He is the senior fellow at the Supreme Court Institute at the Georgetown Law Center. Professor Lederman was Deputy Assistant Attorney General in the Department of Justice's Office of Legal Counsel from 2009 to 2010, and again from 2021 to 2023. And finally, we have Professor Jim Fander, the Owen L. Kuhn Professor of Law at Northwestern University School of Law. His research and teaching centers on federal jurisdiction, government accountability, and civil procedure. Among his numerous publications, he is a co-author of Hardin Wexler's Federal Courts and the Federal System in its 8th edition in 2025, a much-loved book. All right, so I would like to turn it over now to Professor Bray.
Thank you, Mila, and I'm delighted to be able to participate by Zoom and to have the good luck of being able to be on location with my friend and co-panelist, Jim Fander. Over the last 100 days, remedies and equity have been central questions in challenges to the administration. We're seeing a continuation of the new normal of universal injunctions, but with trends like more mandatory preliminary injunctions and more use of TROs, which are ordinarily not appealable. We're also seeing more use of injunctions and less use of vacatur, which is unsurprising given that the administration is largely proceeding through executive orders. And just as the judicial response is in some ways unusual, the executive actions are unusual. There are more executive orders than is typical, and more of them are illegal or unconstitutional. Another major development from the last 100 days is that there are more moves to rein in or possibly end the universal injunction, and these moves are happening right now at the Supreme Court and in Congress. Jim and I will be writing a form of adversarial collaboration, one in a particularly friendly key. We have 6 questions that we will answer in conversation, sometimes agreeing, sometimes disagreeing, and sometimes agreeing with different points of emphasis. In our time today, we will abbreviate our thoughts so much that we will risk bordering on incoherence. You can think of the 6 questions as going to the principles that are behind many of the remedies issues that have appeared in the first 100 days of this administration. Question 1 is about federal equity jurisdiction. How much should we insist that courts ground their decrees in traditional equity? When does that tradition stop evolving and developing? Here, the short answer for me is that equity has to develop and change. It always has, and it's especially important because of what the law of equity does. In particular, it's how our legal system constrains the opportunistic use of legal powers and rights, and it's how we give remedies that are not a matter of right, but are discretionary and kind of channeled discretion. Those tasks, constraining opportunism, giving discretionary remedies, are ones that require responsiveness to new facts and new abuses. So far, I think Jim and I agree. But most lawyers and judges now don't have a lot of familiarity with the law of equity. It's not like that in the UK or Canada or Australia. So if you're going to get authorities from a time when people in the US did have that familiarity, when equity was part of the curriculum, well, those authorities are mostly in the past. So I would lean into what equity has done as a way to mark out what equity can do, always insisting that it is a continuing body of law. I also think it's crucial to think of equity as a body of doctrine. It's not just vibes or aims or flexibility. So I'm a little more likely to lean into traditional equity and to emphasize limiting principles. Question 2 is about the basis for equitable relief. Or to put it differently, is there an ex parte Young cause of action, and where does that come from? The short version for me is that equity doesn't have causes of action, and it's more about whether the plaintiff has the kind of grievance that resonates with what equity does. Causes of action just aren't organizing principles for equitable jurisdiction. It's more like inadequacy of legal remedies, multiplicity of suits, things like that. So I don't lose any sleep over the basis in positive law for suits challenging executive action. It's the patterns and habits of equity jurisdiction. Question 3 will be about Erie, but I'm going to skip over that for the oral remarks. I'll let the Erie question hang in the air, brooding, we might say. Question 4 is about how much we should expect from the injunction and whether some of the load should be shouldered by other remedies. I think we should be leaning more on other remedial claims. Not all of these cases are a good fit for injunctions, and we're in the realm of if all you have is a hammer, everything looks like a nail. So to be specific, in a suit about whether an office holder is entitled to an office, we should be talking about quo warranto, which is at least arguably an adequate remedy at law. That allows a cleaner shot at the legal question without having the courts directly supervise the executive branch. If the payment of funds under a statute or a contract is a non-discretionary duty, and here I would lean on the expertise of the speakers on the first panel, then that's a promising candidate for mandamus rather than an injunction. And in some cases, like the birthright citizenship cases brought by individual plaintiffs, what the plaintiffs really want is not an injunction at all, but rather a declaratory judgment about citizenship. And they should get that and get it immediately. Where I think Jim and I might diverge here is that he looks at all these amazing legal remedies in the past and says, these can all be taken on board by equity. And I agree that the law equity line is porous and movement has happened in both directions. But I also think there's value in distinguishing legal and equitable remedies, especially because they're different in how much they allow courts to manage the parties, which means the legal remedies will tend to be low management and lower conflict. And right now, there's a lot of value to remedial forms that let the courts say what the law is while carefully picking their battles on when they are going to give direct orders to the executive branch. Question 5 is about what interlocutory injunctions are for. I think the answer to this is straightforward. They're not supposed to decide the case. They're supposed to preserve the efficacy of the court's remedial options. In other words, don't let either party take actions now that will moot the case or make it really hard or expensive to give an effective remedy at the end of the case. That answer has implications for some of the current disputes. In a preliminary posture, I would start with a presumption against requiring the government to pay money to NGOs. Now, if the NGO has to lay off a lot of staff or go out of business, sure. If the jurisdictional basis is strong and the merits argument is strong, then the court has to do that. But you generally don't want to require the payment of money, the thing the plaintiff is suing to get at the end of the litigation, upfront as part of a preliminary injunction. I would be more inclined to have the government pay the money into the custody of the court so the court can decide who it goes to and it can preserve its options. Thinking this way about preliminary relief also gives strong support to Judge Boasberg's orders to prevent the deportation of alleged gang members to El Salvador. If it's going to be hard to give them an effective remedy after they're shipped to El Salvador, then the court needs to protect its options by preventing the deportation in the first place. Last, question 6 is about what happens if the court limits universal injunctions. What will be the practical impact of a turn to nationwide class actions challenging executive action? I don't think every universal injunction would be replaceable with a class action, but many of them would be. And that would be a good development in my view. Though I will say there are distinguished people on and moderating this panel with other points of view. It wouldn't help with percolation, but it does have 2 important advantages. First, it would be a proper case. There's a symmetry between winning and losing. If the plaintiff class wins, everybody wins. If the plaintiff class loses, everyone loses. That symmetry is a crucial thing that's missing from the universal injunction. Second, we're more likely to get proper plaintiffs. Part of class certification will be to get named plaintiffs who have a direct interest at stake, who have a strong claim to relative standing, to use Richard Ray's term. Among the many distortions that come from the universal injunction is that it tends to emphasize more peripheral parties, like states. I also expect more orders under the All Writs Act to protect the court's ability to certify a class, like the Supreme Court's recent order that protected what it called the putative class. And I expect more attention to mandamus because it is focused on the officer's duty rather than the protection of the plaintiff. Thank you for the chance to be with you, even if remotely today.
Thank you so much, Sam. And now Jim Fander.
Thanks, Mila. I share Sam's pleasure in our joint Zoom appearance here and in thanking the sponsors for making this work for both of us. I'm also looking forward to this friendly adversarial collaboration that we've got cooking. On question one and the availability or the understanding of traditional equity, I think Sam's right to focus on the existence of a grievance, a threatened invasion of a recognized right, as the basis for invoking equitable authority. But perhaps where we might diverge a bit is on what happens over time as that approach by federal courts to settled forms of grievances takes hold in the law. So think about the trespassory invasion of property to collect a tax in the Osborne setting. The injunctive relief granted there was certainly grievance-oriented and perhaps a bit novel at the time, but it was treated as settled law by the Virginia Coupon cases decision in the 1880s. And I think I would find a greater degree of settled lawness in the patterns of equity than perhaps Sam would. And that feeds into the cause of action puzzle, the puzzle that we identified as our second question, the question of, to what extent ex parte Young has become a part of our law and is therefore an authoritative basis on which federal courts of equity can intervene and resist threatened unconstitutional action by the executive branch. Many people think Grupo threatens that dispensation, and the government is certainly among them, I believe. But I'm not sure that Grupo helps very much, given its appearance in the diversity context, a dispute between private parties, with no federal interests really implicated other than the interest in a neutral tribunal. And in the context in which it has addressed enforcement of law against state and federal government officials in Armstrong and in Free Enterprise Fund, the court's been quite willing to recognize the existence of an ex parte Young right of action without viewing Grupo as a barrier to that grant of relief. And so I would take ex parte Young as a kind of settled part of our equitable tradition at this point, one that's reaffirmed in Free Enterprise and one that's reaffirmed in Armstrong, and one that, as Armstrong indicated, may, as Sam indicated in his remarks, may take on board some of the color of the law remedies that were developed and available at the in the early years. An ability to take common law remedies on board that would be threatened, I think, by a too rigid insistence on the application of the Grupo Mexicano approach. I'll leave eerie brooding as well for question 3, and then turn to an area where I think our disagreement maybe comes into a little sharper revelation, and that's with respect to how to conceive of equitable and injunctive relief today and the degree to which it should remain separate from such legal remedies as mandamus and quo warranto and others. My favorite currently is the writ of seri facias, of course, the writ to cancel patents and other forms of letters patent issued by the government. And the problem that I see with the preservation of a separation is that we labor under a set of federal rules of civil procedure that don't rely on writs, but rely on the availability of a civil action. and rely on the existence of claims for relief. And those are framed without regard to the right of action or the cause of action so much, and not really framed with respect to the content of the relief that would be secured at the back end. And indeed, the federal rules go on to suggest that writs of mandamus are no longer appropriate. And so the rules seem to imagine a world in which, and I think it's the world we live in, a world in which equity has gobbled up, for the most part, these forms of remediation, mandamus and quo warranto, certiorari to some extent, prohibition to some extent, and certainly stare facius as well, and now makes them available, the federal courts do, through the vehicle of injunctive relief. And while it may be appropriate, I think, to understand and define the metes and bounds of that equitable authority by reference to some of the mandamus traditions that developed, it's not, it seems to me, always appropriate to return to those understandings or mechanisms. It seems in some ways as if injunctive relief is the only game in town. And I'll just give you an example. Federal courts have the power to grant relief in the nature of mandamus, the district courts do, but they don't have the power to issue writs of mandamus. How do they go about granting the relief in question? And so I think it's understandable to some extent that the federal courts have sort of turned to the injunction as a kind of all-purpose solution to that difficult problem of managing remedies in the wake of merger. I also agree that Sam has much important to say about the way we go about granting preliminary injunctive relief. And he's criticized Merritt's first approaches to injunctive relief, and he's insisted on thoughtful engagement with the nature of the status quo that needs to be preserved and the nature of remedial options as they might appear later on. But one of the questions that we might ask is, what orders in the recent period that we're looking at would fail Sam's test for the issuance of preliminary injunctive relief? The ones that I have looked at, and I haven't looked at all of them certainly, do seem to have some justification in the multifactored approach that Sam would bring to the analysis, some justification for the grant of preliminary injunctive relief that wouldn't be entirely driven by what is often an overwhelming sense of likely success on the merits. And so even in circumstances where there is no real justification for the suspension of the payment of federal money, you might imagine a decree that takes account of irreparable harm and the impact on the individual litigants as they struggle with the absence of federal financial support that seems to have no real justification aside from a kind of presidential hostility to funding a program that Congress has appropriated funds to support. And here, there's a good deal of support in the history and tradition of mandamus for a fund's direction to be decreed and entered, directing federal officials to let the money flow. That's the decision, of course, in Kendall versus United States versus X. Rel. Stokes, a decision from the 1830s in which the court mandamused and compelled the release of funds from the Treasury to people who were entitled to receive it. And so in that respect, we can see an example, I think, of where mandamus tradition informs modern injunctive relief in a way that I think is consistent with a world of civil action litigation over claims for relief, rather than the sharp separation between legal forms and equitable forms that we might return to. With respect to post-universal, the world of post-universal injunctive relief, I think a lot will, of course, depend on the manner in which the court goes about putting up guideposts. Obviously, if the court forecloses such relief altogether, that will have a dramatic effect and may threaten more remedies than just the availability of universal injunctive relief. There's some reason to think that other forms of all or nothing relief, patent revocation comes to mind, might be threatened or challenged by an expansive conception that Article 3 forecloses all such forms of relief. If it's a more guidepost-oriented approach that leaves open the possibility of universal injunctive relief, then other questions will arise. I agree with Sam that we'll be looking harder at the use of habeas class actions. And I've been quite intrigued by the habeas class action that was certified in the Southern District of Texas to deal with the deportation of individuals who've been housed there on their way out of the country. And that's an interesting class action, a floating class action that will encompass individuals who are also brought to Texas for detention and potential deportation, and therefore will guarantee them the same due process rights that others protected by that habeas class action will now enjoy. But there are limits in the effectiveness of such a decree, limited as it may be to the participants in detention of those subject to detention in the district in question. The government has a great deal of control over the district of confinement, as we all know, and can choose to detain people in districts where no such floating class action decree is available, which will raise the question of whether some broader form of relief might be essential to guarantee the due process that I think we all agree those individuals are entitled to before they are on a plane out of the country. And then there's one final question about the availability of class actions as a solution to the problem of a curtailed or moderated in universal injunctive capacity. And that was reflected, I think, in arguments that we heard very recently about the constitutionality under Article 3 of certifying a class action involving individual members of the class that do not have the kind of Article 3 standing that's required to justify an order on their behalf at the back end of the litigation. It looks like the court will ditch that case as improvidently granted, but the issues will not go away. And if there is an Article 3 concern as to the certification of a nationwide class, it suggests that class actions will be no panacea to the sunsetting of universal injunctions. And I'll stop there with thanks to all of you.
Wonderful. Thank you so much. And now, Marty Luderman.
So I've been listening to some of my favorite scholars for the last 2 hours speak in a very scholarly register, as though this is, and it has been, your typical Stanford Law School conference. And it's really wonderful, and I can't wait to read the papers and the like. And it's all very nuanced and careful and thoughtful and doctrinal and the like. But we weren't having these conferences on the first 100 days of the George W. Bush administration or the Obama administration or even the first Trump administration or the Biden administration. And it feels, quite honestly, much as I agree with some and don't agree with other parts of what my fellow panelists have said in the first two panels, feels a little bit bloodless given what's going on here, right? I imagine that many of you in the audience didn't, come here on a beautiful Friday. You've learned a lot over the last 2 hours. I have too, and it's all wonderful and it will keep you in good stead. But the world is on fire, right? And the question is, what, if anything, this panel in particular, how, if at all, should the courts account for that? And I'll start by saying that I think the Supreme Court justices, most of them, and the Chief Justice in particular, would like nothing more than for their output and their actions to be business as usual, to be in the same sort of moderate register, dealing with hard questions of universal injunctions and the exquisite distinctions that have been raised by Sam and Jim and Zach and Aditya and Peter. And I think they are trying to do so and trying to, in the words that have already been invoked, to temporize, in a sense, right? To put off hard questions in which there will be a conflict between the judiciary and the presidency as long as they can, and to resolve cases on very technical, legalistic grounds that most laypersons don't understand. Is the APA the right method of dealing with the immigration decisions in El Salvador, or should it be in habeas? Is there a class action in habeas? And now this interesting case the court has granted, and really we could spend the next 2 hours, honestly, Mila and Jim and Sam could spend the next 2 hours with an extraordinary discussion of the universal injunction question that the court will hear argument on in 13 days, which is really, really interesting, and I highly recommend Mila and Jim's briefs, and I was disappointed that Sam didn't file one, but he filed a blog post that's mostly the equivalent of one, so I recommend that as well. And it's really, really interesting because I think the court decided to take this question of universal injunctions and not the merits of birthright citizenship, right? Not the merits, but just this question, because it allowed them, or so many of the justices might be thinking, to decide in the abstract what the rules ought to be about when district courts can and cannot, should and should not, be able to issue injunctions that run in favor of non-parties, which is what we mean by universal injunctions. And I couldn't help but notice in Sam's blog post, I hate to call you out, Sam, for this, but Sam's talking about how equity develops, and it's supposed to be sensitive to various different sorts of considerations, even if not all. But Sam acknowledged that if the court holds that a district court judge cannot issue a universal injunction, can only remedy the immediate plaintiffs before them, such that other persons would have to go to court themselves to get similar relief. And we'll put aside the question of whether a district court's declaratory judgment would bind the Trump administration as a practical matter in those cases. Sam wrote that the result would be the continued application of, this is Sam's language, flagrantly unconstitutional executive orders that will cause chaos. And I think that is an accurate description of what will happen if the court rules that way. It's what's happened after the court's ruling in the El Salvador case. What's equitable about chaos and the implementation of patently unconstitutional executive orders that terrorize people across the United States? I don't know. I'd love to hear what you all think about how equity ought to deal with that, or preliminary relief, if not equity. But I thought I would talk briefly, Diego sort of encouraged me to talk about, are the courts going to be, if not a salvation here, at least a significant check on what might be seen as either some unlawful conduct on the part of the Trump administration, or just as frequently taking established law, whether it be judicial law or statutory law, or the vagaries of for instance, the spending statutes, that they are saying give them the opportunity to basically hollow out agencies, not spend it all on those agencies, right, to incapacitate the agencies. Or the laws or the doctrine under SALA law that might allow, the theory of the unitary executive by which the president can control everything that goes on in the executive branch, that all members of the executive branch are his agents and he can remove them, overturn their decisions, perform the functions himself. They're running with all of those ambiguities, with all of those uncertainties, in ways that I don't think the courts or Congress ever contemplated was even possible. They are, right, the executive is not working the way the other two branches thought it might when they decided to provide a great deal of deference to the executive, right? The procedural regularity that they relied upon and that they assumed has been just disregarded wholesale. So what are they supposed to do in that case? What should the court do when it's met with an executive that is using these principles, using this deference, using these broad authorities in ways that seem like, unlike anything that might have been expected or foreseen or anticipated? And I guess I'm a little bit pessimistic. I do think the Supreme Court will rule that many of the actions of the Trump administration are unlawful and will push back against them. Some of the cases might be very easy, the law firm cases, the higher ed cases, just all of these cases in which there's a threat or an actual withholding of spending of grants or other benefits or access that has already been afforded to these entities on grounds that are palpably, if not before you even get to constitutionality, for which there is no statutory basis, that are illegitimate reasons of either vengeance or just basically using the leverage of the federal government to get these civil society institutions to do Donald Trump's bidding. Those cases are going to be easily resolved against the president. So there will be some pushback, and the Supreme Court, I think, in most of the cases, will rule against the president. So why am I pessimistic? Well, let me put it in three basic kinds of reasons. Number one, some of the things the president probably does have the authority to do, maybe even on the hollowing out of certain agencies. I think it's very much a statute by statute sort of decision. But the Supreme Court might decide that a lot of what the Trump administration is doing is lawful, or more importantly, I don't think that any of the justices want the Supreme Court to rule against the president in 80 or 90% of the cases before them. They're going to be looking for cases in which they can give either partial or full victories to the Trump administration because they know they will be ruling against them in others. For the good of the republic, not just so the judiciary doesn't look extreme or something like that. It's not a good system if the judiciary is ruling against that the president's acting unlawfully on a weekly basis. And so I think that's what they've been doing already, giving them partial victories, but trying to hold back and put in place what's really interesting, this would be our 2-hour discussion on the injunctions question. The court itself seemed to issue an injunction against particular deportations of folks to El Salvador. I don't know where they got that authority under equity. That's a nice point made in the Common Cause brief in the case before us. But so that's number one. I think there will be cases that will surprise some people where the courts rule in favor of the Trump administration, or at least give them half victories. Number two, the courts historically have been very, very reluctant, and with very, very good reason, not to second guess particular sorts of decisions that the president makes, particularly in the area of foreign affairs and national security. And I don't think the court is very eager to jettison those doctrines and that form of deference just because it's finally met with a president who they might think does not warrant that kind of respect because he's willing to say just about anything. And here I just want to share with you something that really, really struck me. In the late 1940s, in the last time the court dealt with the Alien Enemies Act, it was a case in which President Truman, after the fighting, the war, in the colloquial sense with Germany and Japan had ended, was removing German nationals from the United States pursuant to this authority on the very technical ground that the Congress and the president had not yet repealed or withdrawn the declaration of war against Germany and Japan. And in a 5-4 decision, the court said that Truman had that authority because of that technicality. Justice Black, in dissent, was excoriating, calling it a fiction. How can you tell the American people that you're using this war power years after the war has ended? This is formalism run amok. It's crazy. And here's what Justice Frankfurter wrote, which is very, very Frankfurtian, but I think actually reflects the way the court has seen such matters, even going back to Justice Story in Martin versus Mott, in a quote that was used by the district court judge in Texas just yesterday for the proposition that the judiciary should not be second-guessing Donald Trump's assertion that the nation of Venezuela has directed this terrorist organization to infiltrate the United States, right? Which all of his intelligence agencies think is not the case, but the district court judges, we can't do anything about it. So here's what Frankfurter wrote. Such great war powers may be abused, no doubt, but that's a bad reason for having judges supervise their exercise, whatever the legal formulas within which such supervision would nominally be confined. In relation to the distribution of constitutional powers among the three branches, the optimistic 18th century language of Mr. Justice Iredell, speaking of the Alien Enemies Act, is still pertinent. Here's what Iredell quoted by Frankfurter. All systems of government suppose they're to be administered by men of common sense and common honesty. I think that describes most of the last 2 hours. In our country, as all ultimately depends on the voice of the people, they have it in their power, and it's to presume they will generally choose men of this description. But if they, the people, will not, the case, to be sure, is without remedy. If they choose fools, they will have foolish laws. If they choose knaves, they will have knavish ones. But this can never be the case until the people are generally fools or knaves themselves, which, thank God, is not likely ever to become the character of the American people, unquote. The Supreme Court, or some of the justices on the court, might think they're now confronting the case described by Iredell and Frankfurter and wondering, what do we do about it? Do we make new rules? Do we temper that deference that we've afforded for very good reason given the executive branch? Under our Constitution, is the remedy here just the electorate and the impeachment and conviction provisions? I mean, I think many of the justices think, look, the problem here was that 10 more Republican senators did not vote to disqualify Trump in February of 2021. That would have solved the problem. The votes couldn't be rounded up. This is what our Constitution provides, and it's not for us on the judiciary to do otherwise. I don't know where the court will go with that, but they will definitely be thinking about this concern. And third, even to the extent the court pushes back, the damage already done in just 100 days to the forms of government that we are all familiar with, that many of us have spent our lives trying to advance and promote, has been incalculable. The president has, and will continue to be able to, no matter what the judicial decisions are, has been able to hollow out the executive branch and the capacity of many, many agencies to perform their functions very deliberately as part of a campaign to say we don't think the executive branch should be doing this. My friend and colleague Jamal Green wrote in the New York Times, some of you may have seen it the other day, that it's, well, maybe I don't have it quoted here, but that it's very unusual that really he's trying to do two things here. One is to exercise presidential power to a degree never before seen in certain areas, like the immigration areas, but on the other, to basically incapacitate the government from doing what it will seem to do. And even if, for instance, as I think is almost certainly the case, the universities and the law firms win their lawsuits against the Trump administration, the power of the purse, even if there's no executive order, those universities and those law firms will not have their phone calls and their grant applications answered, or so they fear, going forward. The executive branch has been given extraordinary capabilities and powers that this administration is exploiting at every turn, some lawfully, some not. And we are now seeing what the results of that are. I happen to be someone who's been in favor of such strong presidential powers being conferred by the legislative branch throughout my life or my professional career. And now I wonder whether that was that and the kind of deference that I described Frankfurter and Iredell describing, I'm not sure what we can do about it, but I'm a little bit doubtful that the federal judiciary is going to be the ultimate check.
Thank you, Marty. That was bracing. All right.
Sorry, I think I was given the bracing assignment.
Yes,
so.
and we are braced. Okay, Melissa.
Great, thank you very much. So I am your resident civil servant. I actually work for USAID until July 1st of this year because the termination orders for all employees for USAID have two dates on them, either July 1st, okay, thank you, or September 1st. When we gather in the interagency, we always joke that we have the suits, which is the State Department, the stars, which is defense, and the scarves. So I've worn my scarf today as your USAID representative. I wanted to talk about work that I'd done at USAID, which focused on, as a rule of law senior advisor, working with lawyers and judges overseas. I focused mainly on cases which, and countries in which the executive is trying to exert power overreach, or you might call them autocratizing countries in a number of cases. And I wanted to look at the adaptation that occurred in those countries and how those judiciaries adapt to what was happening to try to take a larger view of the issues in each case, how they expanded the aperture, how they began to address principles of rule of law in their decisions, and look at how that might be happening a little bit in the United States. But I agree with Marty that, it's essentially, we already are seeing such speed and destruction that the judiciary is not going to be the be-all, end-all. So first, I'll say that it's important to note that in the US, we're facing a new context, and so I share the sentiment expressed earlier that in other countries, people would be out in the streets if things like, the firing of thousands of workers happened overnight. But I think that we are all, and including the judiciary, are shifting our mindset. And so this is happening slowly and over time. So I'll talk a little bit about how this happened in the EU in particular, because I spent a number of years working and embedded specifically in Hungary and Poland. So initially, when the Fidesz government gained a constitutional majority in 2010, some of the early actions that it took had to do with politicizing a media commission and then lowering the retirement age of judges to try to essentially kick out 40% of the Constitutional Court. So both of those resulted in cases at the Court of Justice of the European Union. But the Court of Justice at that point, it resolved the media case as a free market issue, and so it ordered a remedy that didn't take into account the individual speech rights at all. And it resolved the lowering of the retirement age of judges as an issue of just the right of judges to due process, to a proper process. It didn't look at, again, the larger significance of these judges actually being pushed out of the judiciary. So as a result, they were eventually compensated because by the time the case was heard, their positions had been taken by other judges, or a few of them were returned to their judicial positions, but they were not returned to their original positions in power as chief judges, as presidents of courts. They just were called judges. So in the interim, then you have a number of cases related to the Polish judiciary, politicization of the Constitutional Tribunal, which occurred in the middle of the night between 12 and 1 a.m. In November of 2015. You have the lowering of the retirement age of the Supreme Court, a takeover of the body that appointed judges, and the creation of a new political body to discipline judges based on their opinions, so based on their rulings. And so then you start to see the Court of Justice in the EU trying to think about how it's resolving the issues coming before it related to the judiciary as a body. So in a case, it was filed in 2016, decided in 2019, that tells you about the system of justice in the EU. It's a Portuguese case, and it involved the lowering of the pay of judges in Portugal. The Court of Justice, it examined the issue not only related to the rights of judges and changes to what the judges' salaries were, but it also looked at the impact of judicial salaries on judicial independence. It didn't rule that this decision impacted judicial independence, but it said it could if a reduction of their salaries led them to be unable to perform their duties because of lack of resources. And so in doing so, it pulled together several articles of the Treaty on the European Union, Article 2, which states out the values of the EU, Article 4 related to cooperation, and also Article 19, which is the principle of effective judicial protection of individual rights. So in doing this, it established a rule that then, or a manner of review that then became used in a significant Polish case in 2019. And so this related to, again, reduction of the retirement age that attempted to force out 40% of the Polish judiciary. The Court of Justice in that case ruled that a national government, Poland, had failed to fulfill its obligations. So now we're talking about obligations under Article 19 of ensuring effective legal protection. So it has shifted from examining the rights of the judges to looking at the rights of litigants, what's happening to the system itself, and whether rights are being protected of those litigants. So it starts to shift to look at rule of law. So now I want to look a little bit at how we've seen similar shifts, or started to see some similar shifts in how judges in the US are examining cases related to agencies and some of the removal or, quote, deportation. Deportation is a legal term that I think is not what's happening to people, so I don't want to use that term, but removal of individuals from the US. So the very first case filed related to agencies was a USAID case, AFSA and AFG and Oxfam v. Trump. And in that early case, Judge Nichols refused to grant a preliminary injunction because he noted that the employees at issue, USAID employees, were placed on administrative leave. So they're still getting paid. So what's the harm? So, there's no harm, no injunction. This is despite the discussion and presentation of declarations of individuals employed by USAID unable to help individuals in conflict situations in the Congo because they were on administrative leave. Then you see a later agency decision, this is coming in April, 2 months later, where you had employees from Voice of America and Radio Free Asia. They also were placed on administrative leave. They were also padlocked out of their place of employment, similar to USAID employees. And you have a judge, actually, I'm going to note that it's a Reagan appointee, Judge Lambert. I think it's unfortunate that in this day and age, we do look at who appointed judges. The politicization of our judiciary is happening. But I think in the context, I will mention, in this case, it was a Reagan appointee who granted a preliminary injunction in this case, noted in response to the administration's argument that it had not shut down Voice of America, but it simply paused its operations so that they could consider what to do with this agency. The judge found that that's hard to swallow and a waste of 1,300 employees while the president's trying to make up his mind. In this case, I think it's notable that Judge Lambert looked specifically at the First Amendment rights at issue because this is Voice of America. It's a media organization, and did not buy the argument that the Trump administration presented, which was, we are not discriminating on viewpoint. We are getting rid of all employees. So no employees will be presenting any viewpoints. Judge Lambert said no. And so there's a preliminary injunction in place there as that case proceeds. I'll look at a second case. This one, this opinion's quite well known, but I wanted to look at a couple of aspects of it. This is the Abrego Garcia case, which is not an Alien Enemies Act case. This is, of course, a case of an individual who is removed to El Salvador. And the case goes up to the Supreme Court, goes back down, and essentially and goes back to the Fourth Circuit for a panel decision. And so we have, Judge Wilkinson, who delivers a panel decision in April, on April 17th. I will note again, a very conservative jurist. He's criticized the decision in Hamdi v. Rumsfeld, which upheld the government's ability to indefinitely detain a U.S. citizen captured in Afghanistan. In this case, the issue is related to the government's, obligation to facilitate the return of the individual. And so after ruling on the government's motion, Judge Wilkinson could have just provided that ruling, but continued. Went on to address the separation of powers and rule of law issues in the case, specifically addressing the impeachment of judges by Congress and by the administration, stating that the respect that courts must accord the executive must be reciprocated by the executive's respect for the courts. Too often today, this has not been the case, as calls for impeachment of judges for decisions the executive disfavors, and exhortations to disregard court orders sadly illustrate. Also, interestingly, he goes on to discuss the issue of homegrowns being next, and mentions specifically, what assurance shall there be that the executive will not train its broad discretionary powers upon its political enemies? And then further discusses the meeting between Trump and Bukele in the White House, where they both discussed the fact that they were both unable to return the individual. Okay, great. So I will address one more case in 1 minute. And that is the JOP case, which is an Alien Enemies Act case. Judge Gallagher, who is a Trump appointee, I will note, ordered the government to facilitate the return of a 20-year-old and noted in her order the public interest in preventing aliens from being wrongfully removed, particularly to countries where they would face substantial harm, but then also noted the public's interest in seeing its government institutions follow the law. And so I think we're starting to see judges looking at the larger rule of law issues as they are reviewing and hearing these cases. They are struggling, I think, to broaden the aperture and look at what might be called the higher lawmaking authority of judges. And I think they're going to continue to struggle. And just wanted to end there, I guess.
Okay, wonderful. So we wanted to leave plenty of time for questions. I will just kick us off with a couple. So, picking up on Marty's urging that we remain focused on current events and live controversies, I'm thinking of the recent order in AARP versus Trump, where the court issued an order that applied to a putative class of detainees and cited just the All Writs Act as authority for that. Now, I wanted to ask, Sam and Jim, do you think that this? What do you think this case says about the court's approach to universal relief? Does the All Writs Act provide authority for giving relief to putative classes? If so, does it also provide relief to giving relief to provisional classes, or I should have said that the other way around, provisional or putative? And then what does that say more broadly about the Article 3 limits on equitable relief? The second question is, if the court writes an opinion in the birthright citizenship case that distinguishes between relief that is indivisible or unitary and relief that is divisible, what factors should guide the drawing of that line? What is it that a court should look at when it's deciding when relief is indivisible, so universal injunctions are necessary to provide complete relief to the plaintiff, versus cases where that's not true? Marty, I would love to know your thoughts on how the executive branch is going to respond in the event of an actual contempt determination, because we're obviously headed to that very soon if it hasn't occurred during the course of this panel. So what can you please play out what Nick Perillo has called the end game? Like what happens in that end game, given what we've observed over the last couple of months? And then Melissa, I just wondered if you could say a few words about how courts should handle it when an agency action that has been announced hasn't been crystallized or sort of finalized or formalized in the form in which we normally see final agency action. So what sorts of factors should we look at to determine whether something like a review of funds or a freeze on funds is actually like the final agency action of the kind that courts generally review in administrative law cases? So I think I'll hand it over to Jim and Sam.
Thank you, Mila, for the two great questions. So on the first one, the All Writs Act. Now, in my view, the All Writs Act confirms what the powers the federal courts already have without the All Writs Act. Inherent powers to secure, preserve, and then maintain the integrity of the already exercised operation of their jurisdiction. So I think this is pretty important for courts to be courts. I'm not hung up on the timeline of like if you act before you've certified a class. My concern is about using the judicial power in a judicial way, which means for me, part of that is acting in a case. And and part of what the court is doing with the order you referenced, is it's preserving its ability to define the case and to protect the people who will be in the case. And so that's not a problem for me. I think that's distinguishable from universal injunctions when you already have a case and then you're going beyond it, would be the way I would think about it. So I recognize that's a kind of plaintiff-centric view rather than thinking about you're not going beyond the defendant when you control how the defendant acts toward non-parties. On the second question, the divisible, indivisible line, I tend not to be keen on that framing. And that there was an ALI principles statement about 15 years ago that uses that framing. But I find it unhelpful because it's very easy to think about whether the issue is divisible or indivisible. And then you think, well, if the issue is decided one way for this person, why should it be decided differently for another person? And I think the case rather than the issue is the right way to go at it. So for me, the guidance I would give for where to draw the line is that you should give an injunction. You shouldn't give an injunction broader than what you need to resolve the dispute between the parties. And sometimes that will benefit non-parties, and sometimes it will hurt non-parties. And their interests should be taken into account. You should have a wide-angle lens that takes into account everyone's interests when giving an injunction. But that should be the criterion, not divisibility or indivisibility.
On the question of the scope of relief available under all writs and putative classes and provisional classes and the like, I do think it illustrates the overlap between the class action form and the concern with universal injunctive relief. So one thing that lies beneath the surface of the question is if we can do the same thing more or less through the forms of class action certification practice, what then value is there in announcing that Article 3 prohibits the use of the universal or the non-party protective decree? And I'm sympathetic to that view, actually, and think that Article 3 should not be viewed as a key player in the definition of the scope of injunctive relief, that it should focus on a variety of different alternative questions. I noticed that in the argument in the plaintiff class action Article 3 case that I referred to earlier, Justice Kagan was quite clear that for decades, we've been certifying classes without paying a great deal of attention to the nature of the injuries that are of the individuals that are nominally or provisionally included within the metes and bounds of the class in question, and to focus a great deal of attention on the nature of their injury and the need to limit relief to the injuries specified and identified for each particular individual would be to uproot a settled form of class action practice based on a conception of Article 3 judicial limits that are quite similar, I think, to the kinds of limits that critics of the universal injunction sometimes deploy in proposing to limit judicial power. On the question of unitary and divisible forms of relief, I think that is a very interesting and crucial question as we think about the nature of relief that was granted in past years. So I think about Sam's own view that mandamus may be different from injunctions because with mandamus decrees, you're controlling the officer and you're not necessarily focusing on the interests of the plaintiff. And I think it's quite true that in the old adjudicative years of the 19th century, there was a much different conception of the use of judicial power. It wasn't as party focused. There was room for the non-contentious adjudication of claims of right without a formal adversarial arrangement. And courts were empowered to say that mandamus was appropriate with respect to a particular action and therefore provide relief more broadly than the party who initiated the mandamus proceeding. The same would be true with respect to orders that controlled the record. So I'm thinking now of a patent revocation decision that destroys the patent for all purposes and confers benefits on all competitors of the patent holder, not just the party who initiated the proceeding. In all of these situations, 19th century courts were quite willing to entertain power conferred on them to decree in cases of this character, notwithstanding the radiating or ramifying impact that it might have on other participants. And so I think these two examples are relevant to the debate over universal injunctions, but I also share Marty's concern that we're draining the blood out of the moment.
So let me start answering your question here. So in the ordinary course, in any other time in our nation's history, in any other administration, for instance, the Abreu-Garcia case would never have been a case. The administration would have understood that it mistakenly sent someone to El Salvador and would have taken steps to bring him back. Or if not, once the first injunction went out, of course they would have brought him back, and that would have been the end of it. But instead, they read that injunction, as Stephen Miller put it in the Oval Office, as a 9-0, we've been getting these 9 zeros in our favor, sort of thumbing their nose at the fact that the court is trying to be deferential and polite toward the executive, but is trying to get them to do what mature governments do. And they're not doing it. And then you get Judge Wilkinson's opinion, in which he's basically saying, I'm an Article 3 judge. I don't want to issue a ruling giving you the list of steps you should take, have Donald Trump call Bukele on the phone and tell him, get these guys back here. I'm playing my role appropriately, and I'm being met with scorn, contempt, and evasion. And that's what's happening. I don't know, Mila, that they're going to get to the point where they actually claim the right not to abide by an injunction. They've been avoiding that so far, but they've been using every measure imaginable to read the injunctions to not accomplish what they're obviously intended to accomplish, which leads to Judge Boasberg going into, for instance, this contempt proceeding. If I had to guess, and I'm worse at predicting than Aditya even, I'd say that no judge is going to actually hold any individuals in contempt, let alone appoint independent prosecutors or try to do so. I think the point of Boasberg's contempt proceedings is to put on the public record just how aberrant and outrageous the government's conduct is with respect to the judiciary, and hope that that moves things along. I think that's what the Supreme Court is trying to do with its injunctions, which are getting stronger and stronger and trying to meet the evasions with more, with 7 of them anyway. 7 of the justices are, no, we really mean it. At some point, there will come a case in which, right now they're already making noises in briefs being filed yesterday that, sorry, we've asked El Salvador to bring back Abreu-Garcia, and they won't. No one believes that the executive branch of the United States doesn't have the power to do so quite quickly if it wanted to. But what are the courts going to do about that? Are they going to say, no, Donald Trump, you're the ultimate negotiator, you could get him back? They're not going to say that. And the real test will be if and when the court holds, as it should, that the Alien Enemy Act proclamation is illegal, which I think it will. What about the 150 plus persons who are still in El Salvador? What is the administration going to do about them? And the courts will start ordering the administration to do whatever is within your power to bring them back. And I suspect they're going to have trouble getting those orders enforced. I don't know what happens then. I don't think holding people in contempt, holding executive branch officers in contempt for virtually the first time ever is going to be the proposed solution, in part because the Justice Department won't prosecute them, and if an independent prosecutor were appointed, that would be its own whole litigation, and Trump would just pardon everyone anyway. So I don't know what the end game is ultimately, quite honestly, but I'm suspicious that it will not be contempt charges and throwing anyone in jail.
And then related to agency actions, I think that the court should be looking at whether the remedies available have some impact, could have some impact. For example, in the AFSA case that I mentioned, and in a probationary employees case, the courts are ordering employees to exhaust administrative remedies. And so all of the employees have to go to the MSPB where there is no quorum. and the inability to exhaust remedies will just mean that those cases will not get to address the APA or the constitutional violations, and the agencies will be destroyed by the time any exhaustion could happen. So if we're looking at acts that are not final acts, and the courts are examining those acts, I think the court should be taking into account whether their inability to provide any action, any sort of remedy, whether that will leave the agency plaintiffs without any remedy at all, whether the agency, destruction can proceed while the courts are acting, or not acting.
Oh, yes, thank you. Please speak directly into the microphone.
If I've turned it on. Is this working? Yeah, sounds good. Marty, this is mostly for you. It's kind of a quick observation and a rather open-ended question. I would have thought the best way to judge the position of the Supreme Court in particular pivots on Trump versus USA, where the court did exactly the opposite of what I think had it acted responsibly it should have done. What it should have done in that case was to do everything possible to expedite getting the case back to Judge Chutkan so she could decide, whether or not an immunity claim made any sense in terms of January 6th and proceed expeditiously with the trial. Instead, what the court did, to quote Robert, say, we can't worry about present exigencies or what's the other transient results. We have to think about the long-term consequences when you have the most anomalous event in the history of the Republic that you have to deal with, and you should deal with it sooner rather than later. Now, so the question I want to raise is...
I'm sorry, could you speak more directly into the microphone?
Sure. So the question I want to raise is, do you see any implications coming out of Trump versus U.S. With its broad and I still think somewhat unfocused definition of presidential immunity in terms of how one thinks about issues of accountability and responsibility? And responsibility is the key word here, going back to the Article I discussions from the previous session. It seems to me, in some broad sense, although the legacy of Trump versus U.S. remains to be worked out, it has all kinds of ominous implications for the general situation we're dealing with now.
Thanks, Jack. So this is about the Trump immunity decision, but I'll conjoin it with the Trump versus Anderson disqualification decision, which was 9-0. I think they both reflect either the whole court's or the part of the court's view that unusual means ought not to be the way that these things are resolved. Trying a former president for the first time ever for crimes, that shouldn't be used. Disqualification under Section 3 of the 14th Amendment, that shouldn't be used. That there is this silent, the Senate failed in its job, but that's the way it ought to have been resolved. And it's not for the judiciary to come back. I share the view of some that, although I have extraordinary problems with the immunity decision, I don't think that Trump would ever have been convicted before the election. And if he had, I don't think that would have affected the election. So that said, I think a lot in that opinion is problematic, but I think it reflects this basic view of John Roberts, that there are certain ways to deal with things, and it's not always through judicial means, just like I think the contempt power won't be the ultimate answer here. But that assumes good faith and procedural regularity on the part of the executive branch, which I think he was either trying to assume or actually saying that's breaking down in both parties. I think the equivalency was obscene there, but that was the way he saw it. I don't know, now that he's confronted with the fact that he's got an executive that is trying at every turn not to comply with what the Supreme Court and the lower courts are trying their level best to do to get legal compliance. I don't know that there's a particular answer except maybe to stiffen their spine when it comes to closer questions in other cases and start ruling against the executive more frequently. Ultimately, I think that's where the conflict will be, though. At some point, what is the judiciary going to say if the government comes in and says, we tried to get Abreu Garcia back, but El Salvador wants to keep him? I don't know what the best answer to that question is. I would hope never to be confronted with that question as a jurist. But I think that's where we're headed. And I don't think the court relishes the possibility of actually going further and specifying that the president engaged in certain diplomatic actions with other countries or holding folks in contempt. I don't know. I'm curious what you think. I'm curious what my fellow panelists, Samila, think about this too.
Yeah, just in the interest of time, I'd like to make sure we get to some more questions. So, Zach.
Well, thanks. This is all very interesting. I want to offer a thought on Marty's bloodlessness point and see how people react. It seems to me that part of the challenge...
It was a compliment. It's a scholarly compliment, right?
No,
we're supposed to be a little bloodless.
No, I appreciate that. But I actually think it gets at something important about the challenge of for courts dealing with this administration, which is that Trump is a populist, which I think means his pose is to be representing the interests of the people against a set of corrupt and self-serving elites. And part of that is to look at elite institutions like courts, universities, expert agencies, and say, you claim to be following a kind of neutral expertise, but you're really just advancing a set of values that are hostile to us, hostile to the public will. And I think the challenge for courts is that, he'll act on that in an outrageous way, and that makes them want to respond forcefully, but that sort of takes the bait and confirms the narrative that, you're not actually following neutral rules, you're just trying to put us down. And I think for that reason, actually, the best way for courts to protect their authority is to take the kind of approach that Sam and Jim are advocating of kind of, we're following the same rules we would apply in any other case. And that's the way to undercut that narrative, even though it does look kind of bloodless and unsatisfactory sometimes. So I'm curious if people agree with that or how they'd react.
I'm happy to say something very briefly. Don't wrestle with the pig. You both get dirty and the pig likes it. That is meant as an agreement with Zach.
And what does it mean not to wrestle with the pig then?
To retort in the same vein of outrageous hyperbole, disregard for the truth, committed reasoning, et cetera. I mean, I do think it's a time for the courts to safeguard as much as possible their legitimacy, their neutral principles, their above the frayness, precisely so they have that power. When they say no, they're in a maximally strong position to say no because they're going to have to, and it's going to be really important, and a lot is going to depend on it. And
do you mind if I ask genuine question for Sam then? Does that describe what you think the court did in the two El Salvador cases in Judge Wilkinson's opinion in Abreu Garcia? Is that the kind of tenor? Because I think that was appropriate for the most part, although I didn't like the habeas ruling of the court. Is that what you're suggesting, or do you think they're getting too confrontational?
I think you take the median between the two Wilkinson things maybe is I'd say the sweet spot. I think the carefulness between facilitate and effectuate is the right way to go for that stage in what is a long game. Like that, and so I think this is the challenge when outrageous things happen. You need to act like it's not normal. But on the other hand, if you just respond in kind, then you lose a lot of the high ground of being a court, and they're going to need that. They're going to need to preserve every bit of capital and legitimacy they can. So that's my inclination, is to basically agree with Zach's take here and think that's very important, not because what the president is doing is normal, but precisely because it's so abnormal.
And let me just say that I agree with the idea that contempt is unlikely, but that contempt proceedings to create a record can be really valuable for these sorts of public support reasons.
Should we do one more? Yeah, we have time for another question. Yeah.
If I can be heard. So I agree completely that
courts are going to need to use every ounce of their legitimacy over the next 3 years. But doesn't that actually require us to specify the model of non-enforcement and what that actually looks like effectively? I mean, this is sort of putting Marty's question back to him and to the entire panel. I think if judges and if courts basically do what is being suggested, the likelihood of dealing with a true non-enforcement scenario becomes more likely, and specifying the different routes that can take becomes more important, so that the non-enforcement route is actually being thought about in advance.
I'll just say briefly, maybe, but I'm not sure. I think I agree with Sam and Jim and Zach here that the court should act in a very measured and, ordinary manner to the extent they can, and not be, not raise the temperature. And I think they've been trying to do that. I'm not sure raising the temperature would be more effective at getting compliance or contempt or something, very out of the ordinary would work. So I'm agreeing with them I just don't know what the end game is here then when there's non-compliance.
Yeah, and I just wanted to stress that the non-compliance is not just that's been looming out there, hasn't just been in these high stakes kind of foreign relations cases. I mean, one of the ones that kind of made me the most alarmed involved the Associated Press, and just a purely plaintiff-specific injunction concerning access of the Associated Press to I think it was a White House press room. And there was a kind of fast and loose attitude by the administration towards that perfectly kind of plain vanilla classical injunction that was really concerning to me, because there weren't any of these other complicating factors of, jurisdiction or sovereign immunity or political questions or foreign relations or really anything else. I mean, it was just a straight up domestic law dispute about constitutional rights with a single plaintiff with a fairly clear-cut claim.
Yeah. Quick last thought. I think, thinking about some issues that have occurred overseas, I do think that judges, I agree that judges should be measured, but I think that opinions like Wilkinson's are doing double duty in that they're deciding the law, but they're also providing, recognizing that there is maybe an audience outside of the administration that's paying attention, and that's the public. And so, part of what judges can be doing is explaining what they're doing in a way that when that opinion gets covered by the media, there is some education occurring.
All right, please join me in thanking.
Did you have a question?
Oh.
No, go ahead. Is that okay?
It'll be a very quick question. I just thought at the end of this panel, someone should try to make Marty feel a little better. So I'll put the question to you.
You've been doing that for years.
I've been trying, unsuccessfully. The question I have for you is, when we talk about, what are the choices available to the court, I also think, we are at 100 days. And what we have seen is that given an opportunity for strategic overreach in the face of resistance from the courts or in face of controversy over conflict between the administration and the courts, the administration makes the situation worse. And so, for example, in the Abriga Garcia case, Donald Trump has said he could get him back if he wanted to. He said that on the public record just very recently. That's an enormous opportunity. And we see that playing out all the time. We see that if the court takes, and I do agree that it has to preserve its legitimacy, it is cautious in the way it proceeds, but it's purposeful. It draws the administration into taking steps that will enable the court to justifiably, the word escalate comes to mind, I don't think it's the right escalate, but maybe step up what it will do to respond. Do you not see that as an argument that gives us some hope that the court actually is operating in a very strategic fashion here?
No, I do, and I do think the second Wilkinson opinion was an effort to do this, to say, I was acting, the first opinion that Sam referred to, I was acting the way an Article 3 judge should, with respect, and drawing these kinds of fine distinctions. And I was met with this: please, please act in the way that the executive branch is supposed to act. But ultimately, I agree. I don't think they're going to say Donald Trump said on TV that he could get him back, therefore we're going to, what, hold the president in contempt until he can do so? I'm not sure about it. It obviously makes the public's reaction to this tension more in favor of the judiciary, perhaps. But ultimately, I'm not sure the judiciary is going to say to the president, you said on TV you could do it. We are hereby enjoining you to do it. I don't know. Do you think that? I mean, I don't think they would.
I'll be brief and say, I don't think it's going to take place in that way. That is to say, so clearly connected between a presidential statement, in a news conference or on the White House lawn or whatever, and then immediately the court sort of jumps on it and uses it as the opportunity to grant that relief. But I think that it will play into some way the way the court proceeds, that it's being gamed. The administration is saying one thing in the courts. It's like Stephen Miller's White House performance. It's saying one thing in the courts, it's saying something else outside the courts. It's engaged in a lot of, if you will, sort of not just evasive activity, but gamesmanship. And I think that it does, I think the court up to now has probably proceeded in a smart way, and I think in a smart way in the sense that it's going to draw the administration into an increasingly difficult position that the court itself can take advantage of without falling into the problem that Professor Price identified of looking like it's, or to use Professor Bray's point, it's starting to wrestle with the pig. It's allowing the pig to display itself in all of its troughness.
Well, on that note, thank you so much to Jim and to Sam for joining us from Chicago. Thank you, Marty, for coming all the way from DC. And thank you, Melissa, as well, for your insights. Please join me in applauding our panelists.
Thank you.